Beginning from here, John Austin definition that you might all be aware about. Right? Elijah command issued from a sovereign power to an inferior and imposed by coercion. It means law has force. Something which is mandatory, something which is obligatory. In violation of that, we may face punishment prescribed by the law when we discuss, debate law in modern sense. But we also face punishment in the form of social boycott or excommunication when law is not written as such, but that become the basis of collective conscience. And that is where John Solomon definition comes. Law is the body of principles recognized and applied by the state in the administration of justice. A new component came, state. We had been the part of the societies which were known as the stateless society. Even their system was functional at that period of time, and then two types of component emerged in terms of state structures: stateless society and state-based societies. The modern concept of law it typically leads to the state-based social structure, where we have a definite pattern of the system, what we call governance. In the words of the legal theorist Cecily Hart, a large system of rules is union of primary and secondary rules. The primary rules impose duties on people to behave in certain ways, and secondary rules, by contrast, pertain to the primary rules. It means primary rules of obligations and secondary rules of recognition, the way law emerged. Then law has many dimensions as part of our structural arrangement. When law is enacted, it is based on the legislation. Conventional law based on agreement, we said conventional law. Law based on custom is known as the customary law, and case law, which is based on the precedents that become the part of. It means law has many dimensions so far its structuring is concerned. Right? And thus, law is the product of general conscience of the people, in the word of legal theorist Van said. Then the father of sociological jurisprudence, Rusco Pound, how he tried to define the law in his word: it is an organized and critically controlled body of knowledge, both of legal institutions and legal precepts, and of the legal order, that is, of legal ordering of the society. And thus, Ronald Dworkin, he also mentioned that judges create a rationally integrated and coherent network of legal principles, which is law. Here, this is supposed to come in mind. Law has many dimensions. Even the judgments, judicial orders also become the law. And this is what I mentioned. The case law based on precedent, right? Customary law based on customs, legal based on legislation, and conventional law based on agreement. So law has many dimensions in terms of its societal understanding. It has a cultural force, more important. It has cultural force. Its function is that of imposing norms of conduct or patterns of social behavior on the individual will. The aim of jurisprudence to study these norms. The philosophy of law, the subject is known as jurisprudence. It is the aim of jurisprudence to study these norms. Norms may vary from society to society when we become more specific in terms of law approach for the ordering of the society. Then law takes the different shapes, what we call customary laws or customs. The law of the land has also critically defined under Article 13.3 of the Indian Constitution. The customs shall also be treated as a law. There is certain communities for having distinct cultural identities, general system of society will not unnecessarily interfere in their day-to-day affairs, relying those people to carry their social ordering based on their own traditional system of behavior, what we call customs, folkways, morage, etc. Right? Then, when question comes, what is the root of the sociology of law as a sub-discipline of sociology? There is no specific agenda as such. The scholar like Eugene Ehrlich, Weber, Durkheim, they are known as the founding father of sociology of law, because they talk about the law rules, the law governs, and thus so society become the functional aspect in terms of its ordering. So, sociology of life, the only science which might discover objective, not purely subjective, and conjectural limits for the phenomenal law. The limit is given by differences in social interactions, and the differences in social interaction may vary from community to community and society to society, depending the social constitution of that particular society or community. So, law may also differs. Why we talk about the law and how law is related to the sociology or vice versa. As we all know, what I mentioned, the sociology is the science of society. It's not mere science of society, it is the systematic studying of the societal behaviors, what Weber term social actions, what Elcott Parson term social actions. Why we talk about the law? What is the need of the law in the society? Whether every time we are going by the large, not at all. So many systems from the beginning of the morning to till night, we have our own set patterns of the informal mechanism of doing, and accordingly we all perform our tasks. But how law affects society, and accordingly how society affects the law, some of the questions before us, what the effect of law and the legal order on the social order. What is the effect of social order on the legal order? Why? Because law is a textual arrangement, a piece of paper. Unless until this textual arrangement is not taking the right shape at the society, law can never become functional in the society. And thus, the basic purpose of the law to serve the society, and this is what we say, the law lies in society and law dies with the society. So it's both way of acceptance of law is equally important in order to make it more functional to serve the purpose in the society. Then, what the effect of law on attitude, behavior, institutions, and organization society, maintenance and change of society, and again the vice versa. What are the effects of attitudes, behavior, institutions, and organization society, maintain society on law? It means law changes with the change in the societal ordering. And society also changes with the coming of the laws in terms of its more reformative approach. Correct. Why we discuss about the law? The reason is very clear. There are many sociological perspectives, beginning from the functional perspective, conflict perspective, then the symbolic intentional perspective. You might have all gone through as part of your this theoretical paper, if you have, right? Why in the law? So one of the model given by a system theorist in the field of sociology, Talcott Parsons, which is known as the Agile model, right? What are the issues which come before the society? So his theory known as a system theory, and one of the model that he propounded known as the Agile model. So here A stands for the adaptation, G for goal attainment, I for integrity, and L for latency. This is what is known as the Agile model developed by Talcott Parsons, one of the system theorists. What are the issues before us? Then we talk about, then we discuss about, then we debate about, then we also argue about the laws. Adaptation, economy, survival. And survival has its wider meaning. It's not mere restricted to your economic survival. Adaptation, how to adjust. Then what are the purpose? Your objective must be very clear. And that related to your decision making process. If it is in the right way, then it will not do any harm. Rather, it will become the basis of the welfare of the society. Then order ultimately will be maintained. So politically related to the decision making, then integrity, solidarity, social connectivities. But as we all know, the society is not mere static, they are also dynamic too. And being part of dynamic structure, if not today, tomorrow, what a system we have, what a system we are carrying, it will witness changes. And where change will come, then everybody, the system will try to maintain the status quo, what we call pattern maintenance. But as I mentioned, we all know, with the passage of time, due to certain internal factors, endogenous factors, or external factors, exogenous factors, changes will come. And when a change will come, again problems come how to maintain the order. And that you might have uh, clearly understand in the Hegelian philosophy, thesis, antithesis, and synthesis. In the field of the law, so far legal order is concerned, we have three main approaches of societal ordering. What we call first one, that the utilitarian approach. You might be knowing the father of jurisprudence, right? Jeremy Bentham. Utilitarian approach more influence on economic theories than sociological ones. Here comes the equality and equity concept. Public good ought to be the purpose of every legislator, and general utility ought to be the foundation of every reasoning. Then the cultural approach, even economic ordering, but economic ordering is supposed to be tuned with the cultural order of society. Otherwise, that will unnecessarily create imbalance. And when it is imbalance, it will be difficult to maintain the order in a orderly way. So cultural approach, rule and values establish people's relationships and contribute to the unity and solidity of the group or society. Then the compulsion approach, which works, but it is not a permanent solution you have. Emphasize power and domination of various types, military, judicial, spiritual, and economic. And here come the modern definition of the law. Law is a codified norm. Certain things have been prescribed as part of various aspects, which are expected from all of us to be done in a particular way, so that our way of doing may not disturb the others' way of living. And if that is happening, if that is going, then no need of the law as such to be the part of compulsion approach. So that's the reference of law as part of social structure arrangement. Then many legal theories that developed, they're not the part of as such for this discussion, but just referential. Illegal philosophy comprising all those theories which formulate legal ideas as the basis of system. Analytical jurisprudence concerned with the legal techniques, and then the sociological theories, relation between legal principles and the functioning society. Because law is a textual arrangement, unless until, as I mentioned earlier, in not working society, society cannot witness the functionalities of the societal ordering. So sociological theories are more important, which generally legal philosophers, especially the teachers, law teachers like, and that create imbalance in the social order of society. Then come why we need the law for the changes, to bring the change, or to maintain the social transformation so that parity may prevail, so that equality may prevail, and we may witness a just society, orderly arrangement. So I am speaking because the reference is that how law can change or order the society in terms of its social working. Right. As I mentioned in the beginning, today we all have become the part of legal culture. Everything we try to see through the eyes of the large. Right. And why we need the large? One sentence I always use. When someone somehow fail to perform his, her, or their duties, this non-performance of his or her or their duties result in the violation of other rights. When something discussed under the Constitution, we talk it the violation of fundamental rights. When something discussed outside the Constitution, we refer it as the violation of human rights. So what are the duties we have as part of the societal arrangement, beginning from the family structured societal arrangements? If we are doing that, then the violation will not take place. Then they don't talk about rights today. After becoming the part of common law method structure, more talk about the rights, less talk about the duties. Violation of duties or failure of duty result in the violation of some rights. This is how we define the legal culture. And the other friends, law function to promote as a social solidarity and civility grew from its competence to prevent or remedy social disorder, Dugard, legal theorist. So if law is accepted, it will continue. Right? If law is not accepted, it will go in hibernation. Right? It become fruitless rather than fruitless. So social society and further social society also depend on the collective conscience. This collective conscience differ from community in terms of their societal arrangement. So here, one of the legal theorists, a great sociologist, Emile Durkheim comes, who said the law has two bases in terms of his social ordering, depending the social structure of a particular society, the kind of the governance it has. That is the Dr. Jyoti, are you here? Hello.
Yes, sir, we are here only.
You have already discussed as part of this paper Emile Durkheim, his theoretical narrations.
Yes, sir. Discussed Durkheim,
Okay,
Weber,
fine.
Karl Marx,
So
Talcott Parsons.
almost things are known to many of the students, right? So here when we talk about the structure arrangement, two types of the laws emerge in terms of social constructions, repressive law and restrictive law. The common law method depends on the restrictive law. It means it has your echo is hello. It is more on the reform. Right? It means a guilty person will be punished, but after applying the due process of law. This is how we say justice may be delayed but not denied. It may take years, but due process law will be applied. It's not the typical traditional structure of the law making, a law doing, then eye for an eye and blood for blood. That is a part of a repressive law. Or conflict approach or conflict for society. Now, general law of the society doesn't permit such kind of the consideration as part of the law making bodies. The police may apply the third degree, but law as such doesn't permit to go for that. Then comes custom. Here, the name of the many social anthropologists comes like Manaski, Radcliffe Brown. How custom shall be differentiated from the law, or how law can be differentiated from the custom. So in societies we know that there are certain rules which we are supposed to obey as part of that structure arrangement. Violation of that rules may result in excommunication and social boycott. A question may arise in our mind how the force of law in terms of customary practice as customary law will become enforceable in the societies. So that is the basis of collective conscience. Moral obligations. So later part of the discussion will also talk about the what is morality all about. Right? Moral obligations. If decision is given by a caste conscience or tribal conscience, how the decision will become binding. It is the only basis of morality or moral pressure, collective conscience. We are the part of that given social structures. In order to survive there, we had to follow the order of that societal structure. And many instances are there where the apex courts or respective high courts mentioned that caste tribunals or tribal councils have the rights to prescribe their own rules and regulations. The formal law will not interfere in their day-to-day affair or their structural arrangement unless or until that is not contrary to the needs of justice and fairness. And fifth and sixth rule of the constitutions are two best example of such kind of the arrangement, where even the an enactment of law by the parliament will not become applicable in case of the sixth schedule, which is also known as the mini constitution itself, unless and until the autonomous district councils or regional councils of those states are not taken into considerations. Here come the emphasis on the culture, where culture become more powerful than the law, because law is one component of the culture. Law is not the whole, rather it is the part of the our societal arrangement. That's why we have to understand the law in the totality of human behavior, not consider law as the totality of human social aspects. Right? And that's the reference of how law and morality become the problematic area of jurisprudence. Culture is concerned with the intellectual, spiritual, and creative aspects of collective life. What Tyler mentioned, one of the most scientific definition given by the given by anthropologist E.B. Tyler, culture civilization taken its wide ethnographic sense is that complex whole which include religion, law, science, art, morals, customs, and any other capabilities and abilities acquired by man as a member of the society. It means culture rules over the general order of society. The general order may be referred as law or custom, depending the formal and informal social construction of the society. Right? Thus, morality becomes the basis of social ordering. Now the question may arise, what is morality all about? So what ought to be done, what not to be done, we define the morality as such. But what ought to be done, what not to be done, this notion of morality is also very problematic, because morality itself is a very vague concept. What is moral for me may be immoral for you, what is immoral for me may be moral for you. So it is a relative phenomenon. It varies from society to society, but society prescribes what is required based on the general level of society. Accordingly, society will work, or society may witness conflict in its social ordering. Thus, law is not a product of accidental or arbitrary origin, but it grows with the growth and is strengthened with the strength of the people, and finally dies away as a nation loses its identity. Okay. So more emphasis on the culture, our values, law will intact. As I mentioned, the acceptance of law and respect for the law is equally important. When we have less respect for the law, there will be more conflict in the general order of society. Right? So large concurrence with the morality also makes people to obey the law in order to sustain the social life of the society. When coming on the part of the relations between law and society in India, so we have witnessed three major development stages so far the change in the legal society emerged. The traditional of indigenous way of doing things, typical informal mechanism, what we call the era, the stateless societies, right? Acephalous societies, acephalous society, state-based society. The colonial, what the development we witnessed during the British Raj system, how they changed the social interest people in terms of many types of social reforms, for which country also received criticism, name of traditional rigid order society, what we call caste system, and that social stigma, what we still carry one way or other way, that is the untouchability. What the reform took place in that name, and how they brought a major shift in social interaction of people, where everyone interested to work for everyone without any kind of prejudices or biasnesses. Then many things came when we became the part of common law method structure, with the establishment of First Law Commission under the chairmanship of Lord Macaulay. right? And then we received the IPC, later CRPC and CPC. Today that is further change in 2023, right? Then many other schemes, the Succession Act, the Evidence Act, the Contact Act, the Trust Act, the Transfer Private, many large. And this is where we say we are the people of large, the kind of the large numbers India has, we will not find in any other parts of the world. But at the same time, it is also true that many of us, majority term may not be appropriate, who are law avoider rather than the law avoider. And where tussle start between the law and sociology as part of discipline or as our study points. Okay, so coming to the second part of this whole discussion, right? How law changes and how society changes in case of structural arrangement. This is how we try to understand the social phenomena. The process of democratic decentralization had been intensified in rural India by instance of Balwant Rai Mehta Committee. This is the historical journey of the Panchayati Raj institutions, how that paved the way for the more inclusive policy of societal governance, which is not having any kind of biasness or prejudice. In typical way, the sabka saath, sabka vikas. But even being part of the sabka saath, sabka vikas, whether that is happening, not at all. Being formal representatives, right? The system working like a de facto factors rather than the de jure factors. Someone else is decision maker on behalf of those elected formal representatives. Thus, it is basically defeating the basic purpose of the governance based on the rule of law. Here come the sociology, here come the society. When such things are happening, we have to also see the social concept society, why people still prefer that male domination in given social order when we are the representatives of weaker sections, higher caste dominations, when we are the representation of the women in farm system as part of the panchayat institutions, but their decisions are taken by the males. Here, sociology come, we have to understand the social realities of the governance, then law will become more functional in order to bring more change. Then come the positive direction of social change has also been taken place in the fields of science, technology, and manpower. It means today, if you see, technology has entered even our private affairs. This is changing the total social scenario in terms of our privacy and our social connectivity. How law can be helpful in such a situation? From the societal perspective, where technology must be limited or restricted in order to not to violate the private affairs of the people, right? So here study becomes more important in terms of sociology rather than the law. What is because law has own limitations. Our collective consciousness is required to make law more fertile, right? And when it is not happening, it creates the problem for the social change. A social change become bane rather than the boon. Today we talk about theoretical lessons in the sociological fields. Many changes occurred. Modernity had already over. Today we are the part of the postmodern structure or other theoretical nations, the post-modern society, post-strategic society, post-industrial society. Then the globalization coming, right? Our post-globalized society, modernity is already over. Now more talk about those critical aspects of society through which system the government tried to bring a positive change related to the welfare of the every person society. But what happened in the past, in the name of the change, the name of the development, the majority of the people of this country all over the world, and majority of them belong to the Majesty of society, whom we refer the indigenous people in international law, and here in case of our we talk about the scheduled types or other mind sections, they still struggling to have their pace with the mainstream social arrangement. It means the way development support to be done, it has not gone ahead. The reasons, in the name of the displacement, without any proper rehabilitative and resettlement policy approaches, people are struggling to have their proper survival. Having the tuning with the Article 21 of the Indian Constitution, what we say, right to life. It's not mere right to life, dignified life. So today, the era which we are passing, it is the era of contradictions, critical legal studies, critical legal thought, where we have failed the development. In the name of development, we have destructed the nature. But now nature is giving fury in the form of climate change, environmental degradation, soil erosion, that is affecting the whole lot of societal survival in terms of health. Now, how law will work in such a situation? After the major incident, just yesterday, the Bhopal, one of the major tragedy that happened way back in 1984, Bhopal gas tragedy, right? The blast of that tragedy is still there. Someone has failed. People are still facing, still struggling, right? To get hygiene, to get proper health in terms of proper supply of safe drinking water. These things are happening. How law and sociology, a law society will work here in more respective way so that system may witness parity. Why I mention this? They are the context changes that brought major change the birth, the disaster of the Bhopal gas tragedy, the result in the first time country took a positive step to enact the law, that is the Environmental Protection Environmental Act way back in 1986. So changes occurs, changes also come the law when change happens society, whether it is positive changes or negative changes. This was negative change, disaster, but law was brought. And then the principle of polluter pay principle came into existence. This is where law and society are interconnected, and the task of the legal theorist as well as the sociologist to study both things. Right. Now, coming on the third part of this discussion, right? That is the interdisciplinary approach. But before that, why we talk again the law, concept of equality. Why we need the law? As we always say, just to maintain the just society, orderly society. And how orderly society will come? Typical applicability of Article 40 of the Indian Constitution. So, as a law student, if you go by that, then everybody is supposed to be treated equally. Okay, in the eyes of the law, everybody is equal. But whether everybody is equal in reality, in the eyes of the law, this is the matter of discussion, debate, argument, and comments are required. Because a policy was applied for the mainstreaming of the certain section of society, but that policy, with the passage of time, received too much criticism. The policy of affirmative action, a more specific way in case of us, what we call the policy of reservation. So if we go with the typical meaning of the Article 14 in the Constitution, then 15.1 and 16.1, and coming from 15.1 to 15.4, 15.5, and 15.6, they are the subclause of Article 15. Then 16.1, 16.4, and 16.5, and 16.6 do things. There is parity, there is equality. If you apply the law, not at all. And that's why the policy has been referred as compensatory discrimination, positive discrimination, protective discrimination. It means this is a discrimination, prefixing against something to bridge that gap that created imbalance in the general ordering of the society. So how to create a parity, how to make a balance, this policy has been applied. Thus, Article 14 has its further literal interpretation in terms of bifurcation. That's not mere equality before the law, but equal protection of laws. We have 15.1 says, states shall adopt all appropriate measures not to discriminate anyone in the name of attached social labeling, caste, region, religion, creed, language, race. But whether same true in case of Article 15.4, 15.5, 15.6? Not at all. There where we say with the equal protection of laws. So law is all about interpretation or misinterpretation. And when law becomes a part of interpretation or misinterpretation, the morality of profession or morality of societies both are in question. The morality of society says if a person is a murderer, nobody is supposed to help him in the judicial structure because he is a murderer. Every Kasab kill people during daylight, but it took almost many years to find, right, for decisions. But morality of profession says whoever is coming to you, you have to help as part of your barship, as part of your legal profession. So morality of profession and morality of society are always a question. Morality, that's where line sociology as part of discipline in terms of their social connectivities are interconnected, interrelated to be studied. So equality has many conditions, many opportunities. Then equality in what extent? Equality is a legal doctrine, generals, right? Each person is to have an equal right to the most extensive basic liberty for others. But equal right from 15.1 to 15.4, 15.5 and 15.6, whether we carry same way, not at all. Social and economic inequality are to be arranged so that they are both to the greatest benefit of least advantage and attach to the offices and positions open to all under the condition of fair equality of opportunities. Typical applicability of Article 15.1 of the Indian Constitution or 16.1 of the Indian Constitution with respect to the Article 14, which talks about the equality before the law and equal protection of laws. This is a statement which is given by Justice Prasad, right, in A.K. Thakur vs. Union of India case, which paved the way for this 27% of the reservation way back on 10th April 2008, right? And this statement was also taken by Justice Prasad from the case that happened honorably Sarkar versus State of West Bengal, right? What is Article 14 in our constitution? Whether it is for the goodwill of society or in terms of bifurcation, it is more, if not destructive, not offensive, maybe divisive in terms of its societal approach. What I try to mention here, the expression equality before the law and equal to law under the Article 14 of the Constitution are not just dull, lifeless words, static and hidebound as in some mummified manuscript, but living flames intended to give life to a great nation and others being uh, tongues of dynamic fire, potent to mold the future as well as guide the present. Thus, life of law has not been logic, it has been experience, the felt necessity of law, the prevalent moral and political theories, intuitions of public policy, avert and unconscious, even the prejudices within which judges share with their fellow men have had a good deal more to do than the syllogism in determining the rules by which the men should be governed. Now, this see where we need the law, equality and equity. If you see this picture, it will be very clear to all of you why we need the equal, not equality before the law, but equal protection of law. This is how we define the policy of affirmative action, how we refer the policy of affirmative, protective discrimination, positive discrimination, preferential treatment, right? This we can better understand in our terms of our workability. Inequality, equality, equity, justice, all are directly related to the system where we the law as a lawmaking bodies. Right. With us, every official from prime minister down to a constable, or this is the meaning of the equality per se, or a collector of taxes is under the same responsibility for every act done without any legal justification as any other citizens. Professor Dicey. Right? The Constitution of India has sought to create a new social order premised on the liberty, equality, fraternity, and justice to all, social, economic, and political. If that is there, then the rule of law we will witness. If that is not there, if there is any conflict, there is disorder, then the rule of law need to be become the part of rule of law so that parity may prevail, so that justice may prevail. Right. Now, why you as a law student need to study? Because you might thought just study about the everything that related directly to the law, not that is directly to the law. So why need the study about sociology, about economics, about history, about political science, maybe philosophy, maybe psychology? Here comes the relevance of social sciences for legal education. When this modern concept of law school came after the founding father of law schools in our country, late Professor N.R. Madhav Menon. Right. Now see here how Richard Johnstone suggested what is needed for a law teacher. Learning about law involves seeing law as a phenomena located in society and history, interconnected with other political and cultural institutions. Legal phenomena can be studied and analyzed from all sorts of perspectives, and legal issues should be concerned with equipping students to perform the task. Right. So law teaching must necessarily be designed to convey an understanding of law in its totality. In all its sub aspects, it must aim and tend to cover every kind of problem relating to law. Because, as I mentioned in the beginning, law is a textual arrangement. What are the legal intricacies in applying to particular legal enactment or legal enactments? Unless or until we are not trying to understand society arrangement, law will be taken back. Today, you just might read in the paper, Sarthi Ape, where the minister, Mr. Jyotiraj Sindhi, also, now government took back that. It means that it is not serving the purpose of people for which it was made. And finally, government decided to take it back. Right? It means law was not tuned with the tuning of people's exceptions rather than the prescriptions. That we try to understand the legal entitlement. Legalization has witnessed a drastic change in curricula, where emphasis being given on the basic understanding of social sciences and humanities, such as sociology, what I mentioned earlier, economics, philosophy, history, political science, criminology, and so forth. In 1907, the father of sociology jurisprudence, who later known as Rusco Pound, concerned again legal educators becoming legal monks, Pound argued that American teachers of law should know not only court decisions and the principles upon which they were based, but also the circumstances and conditions, social and economic, to which these principles are to be applied. And this is where other social science teachers differs from the law teachers. The other social science teachers, some of them or many of them have field exposures. In case of law teachers, we see rarely them there. Right? So, unless or until you are not understanding the intricacies of the societal norms, you cannot make law to be forcible, or law to be applicable, or law to be more functional. Right? Because till date, there no study has been done in proper way, what the sociology of law of Indian judiciary. Because here, if you criticize any judgment given by the apex court of this country, you may face the contempt of the court. But whether same apply in case of other parts of the world, not at all. In European countries, in USA, every citizen of the country has every right to criticize the judgment given by the apex court. Because who are delivering the judgment, they are also the human beings. They may be wrong. Here differ the legal meaning of the law in context and social meaning of the law in the context. As part of contempt of court or to the human beings, because judges also human beings, they are not coming from any other parts of the world. Right? Why a particular client is more. Just please wait 2 minutes. I will take pause. One phone is. Sorry for disturbance. Okay, so why? But what I was trying to say, what is sociology of law in Indian judiciary? Our bar and bench will discuss about where particular client interested to take a person belonging to his own caste, or region, or religion, or language. This kind of study has not been done, and in many cases are there where that connection and interaction also affect the decisions of the judges. In India, we have not gone for that kind of the sociology of law or study of the bar and bench, how that is affecting the social norms of the general society. Right? So, modern teacher of law should be a student of sociology. It means to understand law not a part of society, but as one complete society which can be studied only in its totality of the human behaviors rather than the partial aspect of the human behaviors. And for that purpose, now the modern teacher of law or modern student of law is supposed to be equipped with all kind of the things that will definitely help him or her when he or she will enter in their next phase of professional life. So when they're having a knowledge of the field of economy, field of sociology, then they will justify the social ordering in more better way than the traditional way of law teaching. This is what mentioned by Rusco Pound in his monumental work, The Need for a Sociological Jurisprudence, that the modern teacher of law should be a student of sociology, economics, and politics, as well as he should know not only what the court decide legal principles by which they decide, but quite as much the circumstances and conditions, social and economic, to which these principles are to be applied. Therefore, the duty of American teachers of law, that the reference for there he mentioned, due to their teaching the color which will fit new generation of lawyers. For example, Sabrimala case. If you go by the typical way of law doing, then you may say that yes, everybody should be allowed. But it's the sociology of that idol, then you may think differently that the reasons, even till date, that case has not been sorted out finally. The reasons, then you think why there are certain norms, because if you see this another case, Ayodhya case, right? Nowhere word you will find where the idol was also one of the party in the court, Ram Lala Birajman. This is where sociology comes. This is where society comes in between the law, because law is supposed to go with the society, and according to society adjust with the system. If law is against the society, law can never serve the purpose in the society. So interdisciplinary approach as part of. Dr. Jyoti, can I continue another 10 minutes? Hello. Hello. Am I
Yes,
audible?
sir. Yes, sir.
Okay. Right.
Yes, sir.
Okay. So historically, the role of law schools has been to teach students how to think like a liar. Now, question comes: who are the liars? Where everybody can take the liar in terms of justice delivery, because justice has become a very costly affair in this country. We'll come later on that part, right? With legal reasoning and analytical thought process, it has become clear, however, that thinking like liar or that matter, thinking like a psychologist or thinking like a social worker is not sufficient when working in an area like child law. When you're dealing with the under trials in the prisons, you also need a social worker. Because you attain social work, you may also need a psychologist, right? Then you will be in a position to provide a proper legal aid to that person. But mere as a law person will not help. Mere as a lawyer will not help. You also need the help of a psychologist. If certain prisoners or not are struggling with their mental trauma, their social trauma, the law person not helpful. Rather than a person belonging to psychology is more helpful. There's certain societal issues where a person belonging to sociology or social work may be more useful than a lab person or liar. This is where we need the multidisciplinary approach or interdisciplinary approach for the ordering of society in more general way. Thus, the format of inviting faculty and professionals from diverse disciplines into the university classroom can provide students from one discipline the opportunity to challenge the assumptions, perspectives, and practices of another discipline within a safe learning environment. This is where we call the integrated course, whether we take what the BLLB, BBLLB, BCom LLB, it means lies there, or BSc LLB, right? और बेसिक टेक्नोलॉजी समाज still thinking that they will need the course of the BTech LLB. Some students are now planning, right? So we need the combination of law with other structured societies to serve the purpose in the society, and that is what we call the multidisciplinary, interdisciplinary. The many dimensions also the disciplinary approaches, transdisciplinary, cross-disciplinary, right? We're not going into detail. So general knowledge based social sciences can help students to maximize the professional benefits from a legal education and develop legal competence. Right. Now, what are the goals of interdisciplinary education that has been further critically emphasized under the NAP 2020 National Education Policy or National New Education Policy 2020? Why we need the interdisciplinary approach as part of integrated course structures? Universities and higher education system they are also preferring even the life schools because there are certain topics of research interest, whether it for the PG students, LLM, or for the PhD students, right? You need also a teacher of economics. You also need a teacher of sociology. If not as a core guide, you also supposed to be a co-guide so that you can justify with the topic as part of your research orientations. So, creating an atmosphere of mutual respect and appreciation for the relevant disciplines, thus enhancing and encouraging teamwork. Remember what generally last one miss कि सोशलॉजी तो हम पढ़ ही लेंगे कुछ भी कर लेंगे तो सोई जी फैमिली मैरिज किनशिप रिलीजन वी ऑल नो इट knowing writing in a precise manner in a given time frame, right, with the relevance, you need your thorough and deep study. So never take any subject as taken for granted. इसमें तो हम पढ़ ही लेंगे इसमें तो कुछ ना कुछ लिख ही लेंगे जो है राइट सो जो लिख लेंगे वही सबसे ज्यादा फेल होते हैं रिमेंबर दिस treat every subject respect every subject because every subject carry the equal meaning equal marks in terms of so then you will be entitled to get the degree so never emphasize less on any particular subject right? Developing knowledge and understanding of another discipline without necessarily mastering it, enhancing communication among the disciplines in a learning environment, but tends to be less adversarial than a work environment, thereby increasing understanding and decreasing interprofessional animosity. Achieving effective communication among disciplines by learning different vocabulary, learning other disciplines rules and concepts, understanding concepts and understanding concepts if a teacher, when he has to enter the class, if you apply the law, then you're not supposed to give, you're not supposed to delay even for 1 minute. You're not supposed to give the attendance for the students even for delay, or even those who missed their roll call inside the class, if you apply the law. But most of the time, whether all the formal mechanism work in informal way, where sociology as a discipline becomes more important to understand the social behavior of the people rather than typically applying the legal ordering of the society. Right? National policy, as I mentioned, right? It says that in order to globally competitive legal education, the proposal for the establishment of a National Assessment Center, the PARAC, Performance Assessment Review and Analysis of Knowledge for Holistic Development as a standard setting body with the Ministry of Education, indicates that the government is keen to regularly monitor the educational system. Interdisciplinarity in legal can be traced back to Upen Baksij, one of the monumental work of him, right, in Note towards a socially relevant legal education. That was the dream of father of law school professor, late Professor N.R. Madhav Menon. Rather than making them the corporate lawyers, what he was interested with the establishment of the law schools, we will create the social lawyers, but picture is something different. The kind of the fee structure, many of them are preferring to become the corporate lawyer rather than the social lawyer. Because you are doing the task of lawyering, but you're working for someone else and they are paying you huge amount, huge money. Right? Task what to social lawyer to help the needy people. This is where we said the justice is too costly in country like us. Why Indian system, legal system, had not become a part of social engineering what we have in case of European part or in USA. Then 84th Law Commission report, which I already mentioned about the interdisciplinary approach. Right. Now, what is significance coming just 2-3 slides more? Significance of sociology for lies legal preference society. Some of the questions before us. You think as a future lawyer, why are law firms not emerge except in metro cities in India like it had done in the USA? The law in India litigational, individualistic, and not so professional. Judges are blaming the liars, liars are blaming the judges. In between, who? The clients. For every time seeing towards justice, cases are pending. People are already passed their more time in the jail when the kind of the act they did. If that was 1 year jail or 2 year jail, but they're already 3-4 years in the jail. Nobody heard them. Trial was not there. We are living in that country. So please widen your dream, widen your social understanding is something outside this room, not inside the room, where you people can be more helpful, even as part of this student culture in law institute through your legal aid clinics. There are other ways where you can help the people that the purpose of established in the law school in this country. Who uses the lawyers? But everybody can use the lawyers? Not at all. You need the money. कि बेल के लिए 50 लाख, बेल के लिए 10 लाख. Not the arguments, just for bail. Justice has become too costly in country like us. Litigation, pending cases. See here. So legal in India is of theoretical nature. There is no serious concern with the people's problems. Lakhs of cases are pending before us. People are seeing, right? कि जेल में है 4 साल हो गए 23 साल हो गए 6 साल जेल में थे 8 साल से जेल में हो गए 2 साल एक्स्ट्रा हो गए nobody paid attention to a person here when he is supposed to be free 2 years back. So there are the many issues which legal profession and country facing. You as a future lawyer can help to minimize the burden of the judiciary, right? And to create a just society, to win the heart of the people who are really needy people every time they are seeing towards you in order to enhance your social life. And that's the reference of the National Knowledge Commission reports what kind of curricula syllabi we required as part of multidisciplinary approach for the understanding of other social sciences along with the law. Because there are many other considerations, whether law is social science, a law is normative science, a law is science. General discussion lies also one of the social science like sociology and economics, not something different from the sociology and economics. But there are many other discussions, right? Philip Nonet and Donald Blake, other scholars talk about whether law can be considered a pure science in terms of theoretical narrations. So, coming to the last aspect of the discussion, the culture of litigation, this revolves around law education, bar councils, legal practices, all, all are the pillars of lawyers' professionalizations, which we need to intake in order to sustain our social life. Thus, today, income and prestige of a lawyer are two important bases of social stratification within the bar. The role of law lies in shaping social structure. Again, historically and culturally specific, there can be no doubt that individuals mobilize law in their assault on collectivities. Nuclear families challenge the authority of villages, landlords, and lineages over land. In the name of equality, individualism rising day by day. That is creating a chaos in general societies, and because of the individualism, even 3-4 years child is also facing the anxiety, is also facing the trauma. उसको भी प्राइवेसी चाहिए, उसको भी घर में अपना अलग रूम होना चाहिए जो है. So family norms are declining, values are changing. A country who tried to become more individualistic, if you see, that country has now maximum numbers of the psychiatric centers. I'm talking about the United States of America, right? But our situation was something different. We are known for the family system, but now that family system witnessing drastic change in social ordering, resultant many issues are emerging in terms of our social interactions, bringing more anxiety, more mental trauma, more emotional trauma, where sociology can be more helpful than the person from the typical law field. Right? So this is all about coming to the last crisis of justice of the law, where we have failed and what is needed for us. What is truly striking in India is the lack of respect for rules of law, not just by the people, but also by those who make and enforce them. We had the Child Marriage Act, provision of Child Marriage Act after 1920 and Sadha Act to 2006 amendment, but child marriage is still happening in this country. Question comes, whom to blame? Society. And who are participating in child marriages sometimes to be restrained for you? MP, MLAs, police of the areas on whom shoulders responsibilities of the rule of law has been given to make law more functional. But what they are saying, we are also the part of same culture arrangement. हम भी उसी परिवार के पार्ट हैं, समाज के पार्ट हैं. Here come the relationship between law and sociology. Law as a discipline, sociology or law as a system, and sociology as a science of society. So that is more important, that legalism in the sense of a moral ethical attitude prescribing that the legal rules are to be followed because their rules of conduct is not dominant characteristics of Indian behavior and culture. हमारे यहाँ सब चलता है. हेलमेट का पैसा दिया जाएगा तो ठीक है. Teachers will go late in their classes. Students also come. Depending the teachers, student may enter 10 minutes late in the class. But I will tell you, 2006 I joined this university. Earlier I was working at Dihadi Mazdoor in Lucknow University. I'm having now 20 years of teaching experience. 2006 I joined this university and till date, I never delayed for 1 minute to enter my class. And after 5 minutes, I send out the students. I am maintaining my path. Right? So this is the duty. Then you can discuss about the rights. Many of us are law-abiders rather than the law-abiders. Why? That's the reason law is functioning. And then finally comes in the word of legal theorist Eugene Ellick, what the law is about, that the center of gravity of legal development lies not in legislation, not in juristic science, not in judicial decision, but in society itself. तो हम सुधरेंगे, जग सुधरेगा. In the typical words of Sri Ram Sharma Acharya, one of the philosopher of this country, saint of this country. So, कहते charity begins at home. If you are working as son, daughter, mother, teacher, what is the role you are carrying? If you are honest on your role, you are duty bound, then the rights will automatically be preserved or protected. No need to talk about the violation of fundamental rights under the constitution, violation of human rights or the constitution. So with this, thank you everyone for your patience listening. And I think certain extent I succeeded to verify.
Done, Karan? Thank you so much, sir. Sir, we'll just take one or two questions very quickly.
Yes, sure.
Anyone who wants to ask questions can come in front. You can ask from my laptop only.
So, Dr. Jyoti, they are the first year students or sociology this semester?
I'm Yamini. So my question is, in modern society, to what extent do you think law can be used as a medium for social control, like to control the people of the society and other things?
Your name? Hello. May I know your name?
Sir, was the question audible?
Yeah, I got the question. I just want to know the name of the student who asked this question.
Sir, Yamini asked.
Yamini. So, if you remember, in my talk, I mentioned why we need the law. As you said, that in the modern with the social control, why we need the law? Because we don't need the law. We only need the law when there is deviation from the normal functioning. We only need the law when there is disorder in the society. We only need the law when there is a conflict in the law, conflict in the order of the society. So then law will come. Again, remember, but law has its wider meaning. Wider meaning in the sense, not mere restrict the word law in typical concept of law as a codified norm, rather than we have to extend the meaning of the law, and then law will become the force in the form of custom, ritual, norm, folkways, and morage. They all are the aspect of control mechanism. It's not mere law as such. Remember this. Right? Fifth is I mentioned the constitution, especially in case of the tribal India. Specific place. Many of the things which we are doing, so we are doing it in formal way. Law not unnecessary interfering, not unnecessary entering in our, that only enter when deviation takes place. Still we are relying one of the my project which are working on the community mediation, Ministry of Education. Why still people prefer their informal mechanism of justice delivery mechanism rather than the formal justice delivery mechanism. It means यदि चीजें हमारे स्तर पर ही होंगी, हमारे लोगों के बीच में होंगी, द मोमेंट यू गो द कोर्ट वी से द लीगल दिस दैट, बट वकील साहब की स्थिति यह है कि जिनको से पैसा नहीं लेना चाहिए उनसे भी पैसा लेते हैं. ये द हार्श रियलिटी ऑफ सोशल ऑर्डर जो है, वेयर यू पीपल आर सपोज टू कम फॉरवर्ड. तो दिल बड़ा करना है, वही पर्पज जिला स्कूल का था जो है, माधव मेनन साहब का जो ड्रीम था जो है. यस प्लीज.
Yes, sir. Anyone else? Anyone else? Khushi, do you want to ask something? Aishwarya, are you asking?
देखो क्या होता है. एक भी प्रॉब्लम आ रही है कि nobody interested to ask the questions in the class.
No, sir, they were saying earlier, but I don't know why now they are.
But we develop the habit of asking the questions, not for the sake of the asking, but because if you ask a question and teacher, anybody, any expert is capable enough to answer, your question may help to many people.
Yes, sir, definitely.
So
Yes,
develop,
sir.
because now large students are general students, they are losing the habit of asking the question in the class. जो टीचर पढ़ा देगा अच्छा बुरा वही अच्छा है. बुरा भी पढ़ा दिया बहुत अच्छा है, जो कभी ढूंढ लेंगे तो कहेंगे हाँ मैडम ने गलत पढ़ा दिया था, जो परफेक्ट, बिकॉज एक्सेप्ट 3 or 4 स्टूडेंट्स विल नॉट फाइंड जो है 5 in the class who are asking the question जो है. Okay.
Yes, sir. Okay, I think we'll end the session. Sir, thank you so much for your valuable time and such a informative and well-structured session. In next semester, they will be studying Indian society. So we'll try next semester if we can make a session on tribal communities, tribal law, or maybe panchayat system if we could do in next semester.
Because next
Uh,
semester, even we have here at the one paper titled Sociology,
yes, sir.
second Indian society and
Yes,
culture जो है,
yes, sir.
right? So that's required.
So in next semester, I think we can do this. So thank you so much, sir, for your for such an informative and well structured session. My heartfelt gratitude to Honorable Vice Chancellor Professor Devendra Singh, sir, and worthy Registrar, sir, Professor Ashutosh, sir, for their constant support and guidance. And lastly, thank you to my dear students for participating in this session. So thank you all and have a good day. Thank you so much, sir. Thank you so much.
Thank you, dear. Thank you everyone.